The division at the Supreme Court, well, it spilled out into public view this week. Justice Kavanaugh admitting that behind the scenes, the justices are at odds with how to handle the court's shadow docket, which has become a bigger and bigger player during this second Trump term. That, and it seems that Justice Kavanaugh may be watching. My name is Dina Doll with the MeidasTouch Network. Let's break this down. Now, we actually heard from two different Supreme Court justices this week. We heard from Justice Kagan as well as Justice Kavanaugh, and they both had something to say about the shadow docket. Now, if you've been following us and watching the unprecedented Supreme Court focused show that I do with Michael Popak on the Legal AF channel, you know all about the shadow docket. But just in a nutshell, to explain it again, this is when the Supreme Court makes a decision that's not one of their full decisions. It's not briefed. They do not hear oral arguments. It is not a matter of deciding on the law of the case, but it's a decision that they make. And it's called a shadow docket for a reason, because we as the public don't get to see the workings behind their decision like we normally would. In an oral argument, we can hear what the justices have to say about it. We hear what the lawyers have to say about it. But with the shadow docket, we often get an unsigned order, just granted or denied. We have seen some extremely important shadow dockets just this past term. Shadow docket decision allowed the Trump administration to cancel the temporary protected status order for hundreds of thousands of Venezuelans, which means that they can be deported while the lower courts figure out whether or not it's legal to even deport them. There was the shadow docket decision that allowed Trump to send people to third party countries while the lower courts decide whether or not that's legal. And there was also the decision that allowed Trump to fire Department of Education employees while, yes, again, the lower court decided whether or not that was legal. Each of those shadow docket decisions were crucial, important, not only for our democracy, but all for the many, many, many people involved. But for such important decisions, the Supreme Court justices themselves, frankly, didn't get the usual amount of time. They didn't get the usual, the benefit, let's say, of hearing from an oral argument from the lawyers. They made the decisions in a way that we didn't get a chance to see. And Justice Kagan, so eloquently, as always, articulated why that is wrong. Because in particular, she highlights the decision regarding the Department of Education. And she says there was a few issues involved. There was the issue of whether or not the parties had standing, which means whether or not they could legally be the ones to bring these issues to court. Then, of course, there was the issue of whether or not the lower court's order, basically pausing Trump's dismantling of the Department of Education, was too broad or not. When the Supreme Court basically overturned the lower court's order, they didn't say if it was because of standing or jurisdiction or the breadth of the order. So they gave zero guidance to the trial court judge. And how unhelpful that is for a trial court judge to know whether or not their order is going to be overturned for a specific reason. Because if they know why it's overturned, they may do better the next time. Either craft the order in a certain way or know that the Supreme Court doesn't think these parties have standing, et cetera, et cetera. So the lack of information not only hurts the public, because we as the public have zero idea. Is the Supreme Court saying it's okay to dismantle the Department of Education? I mean, we should know this is a democracy. We should have this kind of information. So the lack of transparency not only hurts the trial court judges, but the public. Take a listen to what she said just this week.
Maybe this is the most important thing I have to say about this whole emergency docket issue is the need to explain things. Because, you know, what we started doing when we started doing these things was just issuing orders. But I think that that's not the right way to approach it, because like the orders themselves don't tell anybody anything about why we've done what we've done. And I think there are some things like you can pretty well guess, but there are lots of other things where you can't. And I'll give you an example of this that happened last week. So last week there was a case which it involved a district court order, now I'm trying to, no, it didn't come from this circuit. It was a district court order that basically prevented the president from engaging in various measures to dismantle the Department of Education. And it got to the court, and the court said, no, the district court should not have issued that order enjoining those measures. And so the question is, well, why did the court say that? And a casual observer might think, oh, the president does have legal authority to dismantle the education department. But in fact, the Solicitor General didn't even present that to us as an argument. You know, the merits of whether the president had the authority to take these steps to dismantle the education department weren't even before us. What was before us was a variety of threshold and remedial matters. So there was a question about whether the challengers had standing. There was a question about whether the court had, whether that particular court had jurisdiction over these issues. There was a question about the breadth of the remedial order in the case. And we didn't say anything about any of those things. So that court that issued that order, like, what's that court supposed to think? You know, why did we do what we do? Is the problem that the plaintiffs don't have standing? Is the problem that the court doesn't have jurisdiction? It's just impossible to know. And that puts the court in a very difficult situation. And I think more generally, look, courts are supposed to explain things. That's what courts do. They're supposed to explain things to litigants. They're supposed to explain things to the public generally.
Now, Justice Kavanaugh, his remarks, to nobody's surprise, defends the fact that the Supreme Court is giving zero guidance to both the public and to the trial court judge. Instead, he says that the justices have been having a really difficult time agreeing on how to handle this shadow court docket, which portends even more difficulties perhaps to come during the next term, because I imagine there will be even more requests for these type of shadow docket decisions based on how Trump and his cohorts have been acting. So this could be just the beginning. How does the Supreme Court handle this division? Well, Justice Kavanaugh also says, very interestingly in his talk, that he pays attention to the press, that he reads up on things, listens to things, perhaps even this podcast or the many, many YouTube shows we've devoted to the Supreme Court. Well, Justice Kavanaugh, if you are listening, the lack of transparency, the lack of ethical rules that make a lot of those new justices seem corrupt is not working. He says the reason why he pays attention to these things is he's very aware that the Supreme Court works for the American people. Well, the American people think he's doing a bad job. The American people have losing credibility or losing trust with the Supreme Court. Its reputation, its standing is at an all-time low. Well, Justice Kavanaugh, if you care, if you're paying attention, it is not that hard to change. You could do things like perhaps explaining your shadow docket decisions, perhaps not making things on a shadow docket decision, maybe standing behind civil rights just a little bit more and not always standing behind the rights of a corporation while you're leaving the individual American out to dry. And I'm thinking of just this one decision where the Supreme Court decided that an individual who could no longer choose whether or not to have Planned Parenthood as their primary care doctor didn't have a right to sue, despite the fact that a congressional statute for years, one that was enacted after the Civil War, makes it really obvious that people could sue the federal government in order to enforce their rights. Well, Justice Kavanaugh didn't think an individual had that right, but agreed that a retailer who sold e-cigarettes had a right to sue, even though the congressional statute, yes, didn't explicitly say it. So standing up for the American people and not just the American corporations might help you as you pay attention to your PR. Now, Justice Kavanaugh in his remarks tried to also appear above board and say how he's against all this criticism against these trial court judges, that they're just trying to do their job and that it's really unfair. But he fails to mention some very specific examples that if he were to call out as a Supreme Court judge, especially as a Supreme Court judge that was appointed by Trump, might just dissuade Trump and others from coming after Supreme Court, coming after trial court judges. And this includes the fact that Emil Bove, while he was at the DOJ, according to a whistleblower, was saying to ignore, yes, a trial court judge order. Kavanaugh doesn't call that out, although that would be the easiest example to call out since Emil Bove was just voted by the Senate to become a Third Circuit appellate judge. Another good example would have been the fact that Attorney General Pam Bondi evidently started some sort of disciplinary proceedings against Judge Boasberg for the mere fact that Judge Boasberg is doing what he's supposed to do and not following Trump's bidding. That could have been a good thing to call out. It's a very specific example of what a trial court judge is facing. He also failed to mention the fact that a group of lawyers on Thursday spoke about the fact of the threats, the increased threats they are receiving coming from, of course, again, all the rhetoric from Trump and his allies. Kavanaugh doesn't mention that either. If Kavanaugh were serious about standing up for judges, then he could have stood up for the judges who attended and spoke at the Speak Up for Justice forum about the threats that they received, or he could have spoken up for what Judge Boasberg is receiving, and many other examples. So instead of it being just rhetoric, why not take some concrete action and actually stand up for the very specific things Trump and the allies are doing to our justice system? My name is Dina Doll with the MeidasTouch Network. Be sure to free subscribe if you haven't already so you can get updates on this and many other stories to come.
The truth is more important than ever. Check out our new Truth Over Lies collection at store.meidastouch.com. All 100% USA union made.